Institutions of every kind play a crucial role in society. Running a university is about shaping the future of the country as we train young minds. The Silver Jubilee moment also gives us a chance to reflect on the larger issues concerning our higher education institutions. There may be many issues in terms of policy decision-making on higher education, but I wish to reflect on the state of higher education from a philosophical perspective, from the lens of empathy. I have chosen this lens because I believe that empathy is an essential ingredient in the law, and it is what separates a just society from an unjust one. It is a critical component of justice and facilitates in promoting a compassionate view of justice. For instance, the Supreme Court deals with a large number of cases arising out of motor accidents claims. The judges often look at the human side of the case through a lens of empathy while balancing the technical requirements. In that sense, empathy is not a luxury, but a necessity. Empathy can help break down barriers towards justice. That is why we must also understand education through the lens of empathy. In our educational institutions today, we tend to focus a lot on excellence. We are taught that our lives can be better only if we excel in our studies or in our professional life. However, education can only be complete if we nurture the values of empathy and compassion. Our educational institutions must not limit themselves to promoting competition among students, but also shape their outlook towards life, where empathy is a crucial component and element. Excellence in life cannot go without empathy. Lack of empathy in educational institutions has adverse effects on students. I have been emphasizing on the mental health of lawyers, but equally important is the mental health of students. Not only must our educational curriculum inculcate a sense of compassion among students, but the academic leaders must also be sensitive to the concerns of students. When students leave their home, it becomes the responsibility of educational institutions to establish a bond of institutional friendship with students. We must also realize that different students face different challenges. Only recently, I read about the suicide of a Dalit student at IIT Mumbai, IIT Bombay. It reminded me about the suicide of an Adivasi student in National Law University, Odisha last year. My heart goes out to the family members of these students. But I have also been wondering where our institutions are going wrong, that the students are forced to give up their precious lives in these instances. Incidents of suicide of students from marginalized communities are becoming common. These numbers are not just statistics. They are stories sometimes of centuries of struggle. I believe that if we wish to address this issue, the first step is to acknowledge and recognize the problem. Professor Sukhdev Thorat, one of our senior educationists in the country, has noted that if almost all those who have died by suicide, in particularly situations like Dalits and Adivasis, then it shows a pattern which we must question. In our journey of 75 years since independence, we have been focused on creating institutions of eminence. But more than that, we need institutions of empathy, a term I read in a news article. Some of you may be wondering why the Chief Justice of India is speaking on this issue. Well, because I think the issue of discrimination is directly linked with the lack of empathy in educational institutions. Furthermore, judges cannot shy away from social realities. Instances of judicial dialogues are common across the globe. When the Black Lives Matter movement emerged in the United States after the murder of George Floyd, all 9 judges on the Washington Supreme Court, the highest court in the state of Washington in the United States, released a joint statement addressed to the judiciary and the legal community on the degradation and devaluation of Black lives in the United States. Harvard Law School professor Michael Klarman notes that history tends to forget the equally groundbreaking work that several civil rights lawyers did outside the courtroom in educating the Black community about their rights under the Constitution. In similar ways, judges in India have a crucial role in making a dialogue with the society inside and outside the courtrooms to push for social change. As Chief Justice, apart from my core judicial work, which I take very seriously, and administrative duties, my effort is also to throw light on the structural issues which confront our society. Therefore, promoting empathy must be the first step which education institutions ought to take. Nurturing empathy can end the culture of eliteness and exclusion. This can be done by starting with small steps, allotment of hostels based on entrance marks, which leads to caste-based segregation, putting out a public list of marks along with social categories, asking for the marks of Dalit and Adivasi students publicly to humiliate them, making a mockery of their English and physical appearances, stigmatizing them as inefficient, not acting on incidents of abuse and bullying, not providing a support system, or reducing or stopping their fellowships, normalizing stereotypes through jokes are some of the basic things which every educational institution must stop. In other words, practicing empathy is not just a personal attribute, but it requires institutional change. Institutional change in every walk of life, within and outside the judiciary, including in our educational institutions. In that sense, I believe that empathy can allow us to reflect on the state of legal education in a much broader way. When we approach the law with empathy, we recognize that the people who come before us in the legal system are not just names on a docket or numbers in a statistic. They are real people with real lives and real struggles of life. We understand that their circumstances and experiences may be different from our own, and we try to see the world from their perspective and eyes. That such an understanding should be at the foundation of legal education was the idea behind the creation of national law universities. It was to promote an interdisciplinary learning based on a clinical education model which would allow human interaction with the study of law. To what extent we have succeeded is the foremost question today. In my view, the experiment with NLUs was to create accessible institutions focused on quality legal education and not to create elite institutions. However, the NLUs have been struggling to be accessible to a wide section of society. Concerns are continuously raised about the entrance exam pattern of NLUs, which acts as an access barrier for students not well acquainted with English. Furthermore, any efforts taken in revitalizing the entrance examination would be futile if the internal structures in law universities are not conducive for students coming from non-metropolitan or marginalized backgrounds. Along with this, the financial barriers are also serious. The law universities and governments need to work together to ensure financial accessibility. I would also take the opportunity to highlight that the idea behind the creation of NLUs was not to leave behind traditional law universities or central universities. A majority of judges on the bench, including the bench of the Supreme Court, are a product of what we now think of as traditional universities. Therefore, the outlook of legal education must be to improve the quality of law colleges across the country and not just a few institutions. The sense of entitlement that NLUs are better than other institutions leads to unnecessary wastage of energy. Instead, NLUs should be the leaders in the field of legal education, which could help other smaller law colleges grow academically. NLUs ought not to work in a field of isolation. Law students studying in LLUs must not look down upon their counterparts from other law schools. After all, the legal profession is such that we are constantly learning and teaching each other. The clinical legal model of education would be realized only when we are able to involve law students directly with the legal aid services. In other countries, law students guided by clinical faculty work on real-life cases. This not only provides exposure, but also inculcates a sense of responsibility among them. Our law schools also need to think in this way. Academic leaders, bar council representatives, and members of the bar and judiciary need to sit together and reflect on the state of clinical legal education in India. It is by reshaping our legal education model that we will be able to make empathy a core value of our legal system. We must work to address the structural inequalities that are built into our legal system and to create a system that truly reflects our shared values of justice. I'm aware of the fact that a fresh law graduate stepping into the profession faces many challenges, from getting into the chambers of good offices, the tendency of established lawyers and law officers to pay off meager salaries, even lower than the minimum wages, extremely high fees for registration for state bar councils, to name a few. If we as a legal profession have to grow, we have to change our approach. We would have to move past the mindset that we are reaping as we had sowed. That is, justifying earlier practices as the norms for the future. I was the first of the emergency batches for the BA Economics degree at St. Stephen's College in Delhi University. And when we were ragged, it was as if that we would pass the baton of ragging when it came to be our time to be seniors. But that is really a very poor model for legal education. We must ensure that the practice of law is done in a fair and equitable manner, without regard to a person's race, caste, gender, religion, disability, or sexual orientation. In the context which I have just narrated, my tenure as Chief Justice has focused on improving accessibility in legal education and the profession. The Supreme Court has now launched an e-version of the Supreme Court reports, the ESCR, which allows everyone to freely access around 34,000 reportable judgments of the Supreme Court from 1950 to from 2023. As a result, young graduates like you will not have to spend a penny on accessing judgments and doing research as they join the profession. The court started live streaming and hybrid court hearings, which allows any lawyer to argue a case sitting anywhere in the country. This has addressed the concern that only a few lawyers were able to reach the Supreme Court. During the pandemic, a number of women lawyers were able to actively participate in court proceedings. In one such court proceeding, as we were hearing a young woman lawyer, there was a voice of a baby which straggled across the stream. The young lawyer was very apologetic when she said, "I'm so sorry for this disruption." So I said, this shows us truly that we are an inclusive profession. And this is not something which judges This is not something which judges should grudge, because this is our effort to ensure that young women who fulfill multifold roles in society are able to access the profession on an equal platform. I'm stressing on the increasing use of technology to not only increase access to justice, but also to take it as an opportunity to make the judicial system an epitome of transparency. With this goal in mind, most recently, we have started auto-transcription of court proceedings by employing artificial intelligence, AI, and high-tech tools. By doing this, our court can become the court of record in its fullest sense. The record of conversations between the bench and the bar shall act as an important medium of education, where students can learn about the art of arguing and what type of questions to expect from the bench. In that way, legal education can become more practice-oriented. But let me make things very, very clear. Just to the Supreme Court, and I believe all high courts become high-tech, the purpose of our going high-tech is not to set us apart from the community. The purpose of technology is to ensure that our work continues as it always has been at the center stage of society, deeply associated and cognizant of real life of our citizens on a day-to-day basis. I've also been emphasizing upon diversity and inclusion. Recently, I approved in principle a proposal sent by the National Commission for Scheduled Tribes to have 36 law graduates from the scheduled tribe community come and work at the Supreme Court of India as fellows and get first-hand experiences in the working of the Supreme Court. These students, whom we mentor today, shall become successful lawyers and judges of the future. Furthermore, to ensure that technological developments in courts do not leave behind persons with disabilities, I have constituted a committee on accessibility, which is headed by Justice Ravindra Bhatt, and is doing an accessibility audit of the Supreme Court premises and functioning. Based on their report, we will be making efforts to ensure that courts become disabled friendly. However, before I leave, I wish to highlight that while the Supreme Court initially adopted technological infrastructure to meet the challenges of the pandemic, the same is being retained and developed further to ensure that everyone is now able to access the court from any part of the country and without any difficulty. I do believe that the Supreme Court of India is not the Supreme Court of Tilak Marg, Delhi, but it truly is a court for the nation. I believe that our legal education must also be evolved in the same way. That is to say, while online education during the pandemic provided us with the opportunity to easily interact with researchers and scholars across the globe, it also raised concerns about the inaccessibility of students from rural or marginalized backgrounds. Thus, the evolution of online hybrid infrastructure must be done in such a way so as to ensure that the marginalized and the underprivileged are not left behind in our endeavors. We can now see a number of YouTube channels producing videos on legal concepts in a simplified form. The YouTube is the new world of opportunity in the law as elsewhere. The number of views on these videos indicates the level of curiosity which our citizens have towards legal discourse, and it is our job to make our citizens aware about the law. Therefore, I think technology can allow us to take legal education to a mass level, so that law does not remain a field or profession of the elites. Teaching or study resources can be made available online publicly to students, even if that student is not enrolled in the law school. This can encourage quality learning everywhere. And therefore, I would beseech NALSA, as indeed all the other national law schools, to ensure that the videos of the kind of quality legal education which you provide to your own students do not become a shared monopoly of your students alone, but are disseminated across the nation, so that education in that sense becomes a sort of democratization and the breaking down of feudal and patriarchal structures in our society. It is my sincere belief that with collective efforts, we shall be able to change the approach of legal education and the legal profession. We must use the law to create a society that is truly just, where everyone is treated with dignity and respect, and where everyone has the opportunity to thrive. We must work together to shape the law in a way that reflects our shared value of fairness, equality, and justice. Dear students, as you experiment with law after your graduation, do it with a sense of compassion.